Court calls the case People versus Thomas Vasher.
Every courtroom has a rhythm, a heartbeat, a moment where everything feels routine until it doesn't. And today, in Judge Simpson's courtroom, what starts as a simple bond discussion spirals into a raw display of confusion, credibility, and consequence. This is the kind of hearing that reminds you why bond is never just paperwork. It's a test of trust, a measure of whether the court believes you'll follow the rules when no one is watching. On one side, we have a defendant claiming he misunderstood his court date, believing an adjournment meant he didn't have to show up at all. On the other, a prosecution pointing to probation status, a failure to appear, and something far more troubling: multiple IDs found in his possession. That alone raises red flags. But what really changes the tone of this case is what happens when the defendant starts talking. Because in court, words are never just words. You'll see a man trying to convince the judge that he's turned his life around, riding a bicycle, cleaning churches, picking up trash, living honestly for the first time. You'll also see his own attorney attempt to stop him from speaking, knowing that every unscripted sentence can become ammunition against him. And you'll watch Judge Simpson walk the tightrope between empathy and authority.
People.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Vasher.
Your name?
Thomas Vasher.
All right, what are we doing?
Your Honor, we are requesting an adjournment to obtain some media discovery, and when appropriate, my client would like me to address bond.
He has a bond. Hey, do you have the bond violation report?
I do not have the bond violation report.
This just came in.
Oh, then if it just came in, I would not.
A bond violation.
I don't know.
It's a report that was you.
Oh, you know.
Oh, that's my handwriting.
You know.
Yeah, unless
Oh,
I don't.
You didn't remember.
Yeah, that might be why he's in custody.
Right. That
Got it. Okay, got it. All right. Probable cause conference, June 12th, 2025, 9 a.m. As to bond.
as to bond, Your Honor, I'll be requesting a PR bond on behalf of Mr. Vasher for the reason why he missed his last probable cause conference court date. It did appear he was in communication with our office. He did talk to one of my colleagues. They were going to request an adjournment, and he misunderstood, thinking that meant he would, that mean that he didn't have to show up to that particular court date. So we do have good contact information for him. He is being supported by his church and has been attending programming from Home and New Vision. So I would be requesting a PR bond.
You sponsoring the people?
I do believe the defendant is on probation under the 22nd Circuit Court for assaulting, resisting, or obstructing a police officer. In this case, he was taken into custody, I believe, for a warrant related to that probation. And when he was arrested, he was found to be in possession of several different individuals' IDs or cards, or credit cards of this nature. So I do not think a PR bond is appropriate, and he did have a failure to appear.
Anything else?
I said, I was reiterate, I know he has a support system. He will be appearing in court. We do have good contact information for him, and I will be requesting that.
What do you want to say, Mr. Vash?
Mr. Simpson, Your Honorable Judge, I just want to inform you that every day of my life, I get up and I live with that lady in the back there in the court, and I get on my bicycle and I ride right there, the little lady right there. And I ride my bicycle every day, and I pick up garbage out of churches in school parking lots, and that's where I find
I would advise you to stop making any statements, because those could be used against.
Well, that's just the truth. That's where I even got the credit card.
I would advise you to stop making that statement.
I've done everything right. I'm doing good. I'm really, for the first time in my life, proud of myself.
This moment is emotionally powerful and legally dangerous. From a human perspective, what he's saying resonates. He's presenting himself as someone trying to change. He's painting a picture of purpose, riding his bike, helping his community, doing something meaningful with his days. In his mind, this is proof that he deserves another chance. But in a courtroom, intention doesn't outweigh procedure. Notice how his attorney immediately tries to shut this down. That's not cruelty, it's strategy. Anything a defendant says in open court can be used later. Even statements meant to sound positive can backfire. Here, he casually admits how he came into possession of a credit card. That's not redemption, that's risk. This is the tension defendants often misunderstand. Judges are not deciding who you are becoming. They're deciding whether you will comply with court orders right now. And the problem here isn't his lifestyle, it's the missed court date. The system hinges on one basic expectation: show up.
Okay. I've set this out to the 12th. I'm going to deny the request for a change in bond at this juncture. Is he going to be dealing with the circuit court matter anytime soon? Violation?
I'm not sure of his court date off the top of my head. I would have to check.
Okay. So his bond at this point will continue. Thank you.
So PR bond?
Your bond's continuing. It's not a PR bond.
It's not a PR bond?
Your bond's being continued.
I've been doing everything right since everything. Everything I'm supposed to do.
Okay, you keep talking at me, it's going to get worse. Okay, thank you.
This is where courtroom authority becomes unmistakably clear. Judge Simpson isn't reacting to the crime here. He's reacting to behavior. The defendant keeps talking, keeps pushing, keeps trying to justify, and the judge draws a hard line. Stop. Because in court, respect isn't optional. It's structural. Bond is a privilege, not a right. A PR bond, personal recognizance, is the court saying, "We trust you." When a defendant misses a date, even accidentally, that trust erodes. When he continues speaking after being warned, it fractures further. The judge's message is simple. Every extra word is working against you. And this is a critical lesson. Courts interpret interruptions as defiance, not passion. Judges don't see emotional urgency. They see inability to follow direction. And when the core issue is compliance, behavior in the courtroom becomes evidence.
Versus Stephen Johnston.
Okay, Richard McDuffie for the people. Here to go. And Allison on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Johnson.
All right. I put this over to this afternoon. What have we determined?
Yes.
Good evening. Well, good afternoon, brother.
Yes.
All right.
First, I know Mr. Johnson was able to speak to one of my colleagues when I was in court this morning. We will be, I know we have a green sheet in there. He will be waiving his PE for this to go over to the circuit court. I will have him fill out that form momentarily, Your Honor.
So he's waiving up?
Yes, he'll be waiving up.
All right. Is there any issue I need to do with bond on this then?
Your Honor, at this time, we would be asking for a no contact order to be put in place.
The courtroom doesn't reset between cases, it recalibrates. And this second matter immediately carries heavier weight. A no-contact order isn't about punishment. It's about prevention. It exists to stop pressure, manipulation, intimidation, or emotional leverage before it happens. When prosecutors ask for one, they're signaling concern, not just about past behavior, but future risk. Here, the defense counters with context, prior consensual contact, a victim impact statement requesting communication, and a circuit court judge who previously allowed it. On paper, that sounds persuasive, but Judge Simpson is focused on something else: the change in circumstances. That's the legal pivot point. Courts don't freeze decisions in time. They respond to evolving behavior. And when the judge mentions phone calls that could be interpreted as interference, he's outlining how quickly consent can turn coercive. Even lawful contact becomes problematic when the content crosses into pressure or blame.
I thought you did give the change this morning.
President Kinduski, Your Honor.
Okay, help me. Name. Yes. Go ahead. Go ahead.
Yes. So in addressing the prosecution's request for no contact, Abby is saying per his probation cases, he does have a consensual contact order with the complaining witness in those cases. She did make a 40-minute victim's impact statement confirming that she did want contact. I can confirm this with his APD who represented him at the circuit court level. Judge Kunke there made a determination that contact would be proper if it was consensual contact. Similarly, this was a request that was made at arraignment on this case. I was not myself who handled it, my colleague. However, Magistrate Otella there also made a determination based upon the allegations related to this case, which is two R&Os and alleged two R&Os and a possession that that no contact order was needed. The alleged complaining witnesses in this case before you at this moment would be the police officers, not the complaining witness from his past cases. So I'll be asking for no modification in his bond.
But you would agree that between the time of the arraignment, between the time of Judge Kunke's hearing, the time of arraignment on this case, that certain circumstances have changed regarding that contact, meaning phone calls that were made, which one could look at as interfering or otherwise attempting to try to obstruct this proceeding.
Well, context may be changed. He has indicated that prior to this, he was never near her. I understand the concerns that you're addressing with these phone calls. However, again, they are still not a evaluation of his previous probation. So
right, okay, so that we're clear in what I'm saying. I'm not saying that they're necessarily a violation because the no contact does not exist. I guess I'll put it that way. I mean, it's permitted contact. But once that contact then begins to happen, the subject matter of that particular contact, what's said, could change those circumstances, I guess, in terms of whether or not contact should continue to be permitted. I mean, if somebody calls and is making either threats or some other type of statement to someone, that could lead the court to then change the bond conditions on the case. You would agree with that, would you not, Mr. Buckovich?
yes, I would understand what you're saying, yeah.
All right. Okay. Anything else regarding this case? I'll take the waiver in a moment. You're gonna wait. He's waving up.
Yeah, but you get in front of Kunke.
You know what, Your Honor, I might as well just wave up to Kunke.
Okay.
Okay, if that's what you wish to do. Sir, you
Tells me addressing bond. I'm not changing when it was no contact with her. That's what I was addressing. I'm not going to be my torture. That's not the come over. But you want to be innocent. As to be interested. We are interested in contact with her. Surprise. Just taking that threat. That's my opinion. Yes, I ever did that.
Just one more time to reiterate for the purpose of bond. Those calls can also not be interpreted in a way that is non-threatening. So I would still be asking for a.
You're saying they could be interpreted as a way of non-threatening?
Yes. So I would still be reiterating that I would be asking for no modification in bond and no contact order to be put in place.
This is where legal language becomes a battlefield of interpretation. The defense is threading a very careful needle. They're not saying the calls were good. They're saying they could be viewed as non-threatening. That distinction matters. In bond hearings, the court doesn't need proof beyond a reasonable doubt. It operates on risk assessment. The question isn't, did he commit a crime? It's, does this behavior suggest future harm or interference? And the judge understands that ambiguity itself can be dangerous. What's being argued here is not innocence, it's uncertainty. But courts don't gamble on uncertainty when a human being's safety is involved. When a judge hears that contact might be harmless but might also be manipulative, the scales tilt toward restriction, because bond conditions exist to minimize harm, not wait for it. This is the quiet tension in preventive justice. The defense is appealing to fairness, don't punish without proof. The prosecution is appealing to foresight, don't wait for consequences.
Is there anything from the people on that?
There is, Your Honor. So first of all, I want to point out that at the arraignment with Magistrate Odosella, Mr. Bukovich and I were both present. As he mentioned, it was his colleague that handled the arraignment. There was not an extended back and forth about the no contact provision. We made the request, it was articulated on a recommendation form, and Magistrate declined to order it. But there was no, honestly, it could be that it just slipped his mind in terms of that being a request, and I maybe should have done a better job of reminding him about it. But I want to point out there was not an explicit denial of that request on a basis of it not being necessary. Second, I understand that this was prior to sentencing. In the GBH case that Mr. Johnson had with this same victim, obviously she's not a victim in this case, he previously had an issue where his phone privileges were revoked first. Then there was a motion for forfeiture by wrongdoing. It ended up not being necessary because the case was bound over at exam. He continued to contact her after that, discussing the fact that she did not want to cooperate with the exam from different people's pens. So it's an ongoing problem and it's an ongoing pattern with this case. He made some comments at the arraignment on this case that quite frankly raised a red flag for me with the concern that we were going to end up right here like we are today. The people are requesting a simple no contact. It's unclear to me. I understand that consensual contact was granted by the circuit court. That was in January of this year when he was sentenced on that GBH case and on the possession of methamphetamine case as well. He is charged today on this case with another methamphetamine case and are now emanating from this victim, articulating concerns about her safety with him. We think that the circumstances have clearly, if they were deemed to be appropriate back in January, have certainly changed by now. So the people are, again, requesting a simple but straightforward, no contact whatsoever with this complaining witness in this case, given the history here and the fact that we have a pattern established of a failure to abide by bond conditions beyond the revocation of previous phone privileges.
This is the prosecution's anchor point, pattern. Courts are not just reactive, they're predictive. And nothing predicts future conduct more strongly than past behavior. What the prosecutor is doing here is constructing a timeline. Prior violence, prior restrictions, prior revocation of privileges, continued contact, new charges, same individual, same dynamic. This isn't about one phone call, it's about trajectory. When the state says pattern, they're telling the judge, this isn't a one-off misunderstanding, this is repetition. And repetition in criminal procedure changes everything. It transforms sympathy into caution. Judge Simpson now has to weigh two competing narratives. A defense arguing that contact was once permitted and that the calls might not be harmful. A prosecution showing a cycle where boundaries are repeatedly tested until the court is forced to intervene. And this is where judicial philosophy matters. Some judges wait for violations. Others act when risk becomes visible. Judge Simpson belongs to the latter camp. You can hear it in how he frames harm, not as something that must already exist, but as something the court has a duty to prevent.
All right, here's what the court's going to do. Well, is he waving up or what's he going to do?
Is it getting funky?
Or did you wish for the adjournment, Mr. Burke?
Yeah, I'm quite confused on a couple of things. If I'm able to speak to you for a second, the complaining witness of who they are talking about. I understand my attorney's sitting right here and he's present in front of me. I'm speaking on my behalf. She went in front of Kunke, Judge Kunke, and admitted to her full honest truth that I did not assault her, harm her in any condition or form, okay? And also even stated that drugs were planted inside of a book bag, Your Honor. Was planted inside of a book bag. This is on transcript in Kunke's courtroom, Your Honor. And by me not being able to have contact with her is, I'm confused on it. I'm not being explained or talked to the reason why.
This is the emotional core of the case. The defendant doesn't see himself as threatening. He sees himself as misunderstood. But the judge is hearing something very different: blame. And blame, when directed at a complaining witness, becomes pressure, even if it isn't shouted, even if it isn't explicit. This is where many defendants lose perspective. He's saying, she didn't put me here. But what the judge hears is, you are responsible for my situation. That subtext is powerful. It shifts emotional weight onto the other person. It frames them as the cause of suffering, and courts recognize this as the seed of coercion. It doesn't have to be violent to be harmful. It only has to make someone feel responsible for your fate. Judge Simpson isn't punishing speech. He's responding to impact. The defendant feels silenced. The court feels obligated.
I cannot have conversations with my fiance and soon-to-be wife. When this drug charge had nothing to deal with her, it had to deal with
But you making statements to her that the reason behind your predicament, and I'm paraphrasing this and putting it, is because of what she did are problematic.
what she did.
Because that you're in the circumstance you're in because of her. Those are problematic comments.
Okay, so that's the reason why I'm not able to have contact with her. She didn't put me in this predicament. Her doctor
Sir, I
did a
advise you stop
welfare
making
check on her.
statements. I advise you stop making statements, because this is related to this case at hand.
And can you speak for me?
Sure, I've explained that. So statements can be used against
Do
you.
you wish for me to adjourn this rather than to
No,
waive
give me the pen.
Yes.
I'll go in front. I'll go in front of council, man. Have yourself a good day.
really hope he didn't run or act that way. So you signed this waiver of preliminary examination?
Correct, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah, I do, Your Honor, even though there wasn't one committed, but yes, I have to.
I'm not
get it.
taking his waiver. I'm just going to adjourn this out. You can talk to your client. He can figure out what he wants to do. I'm asking very simple questions. He seems to get angry at me.
I'm not.
I don't even know why. I'm making the findings based upon what's presented to me. But if he's going to act this way, I'm just not having it. So
Would you like to briefly pass this matter so I can speak to
no,
my client? Your
I'm
Honor?
not going to pass it. I'm going to adjourn this to another day.
I'm not mad.
I'm going to adjourn this to, give him 1 week out. We'll go June 5th, 2025, 9 a.m.
Mr.
His
Simpson.
invite indicates I am at this time going to change the bond conditions. I'm going to leave his bond in its monetary amount as it's set. I am going to order that his phone privileges at this juncture are revoked. You could bring that up again at the next hearing. I'm also going to indicate that there's no contact with Christian. I'm going to order that at this point, and then he can decide what he wants to do with the case. But if he thinks I'm going to put up with his behavior, I'm not doing it. I'm
Your
done.
Honor,
Thank you.
I'm not upset, Your Honor. I said just.
This is the moment where judicial patience becomes judicial boundary. Judge Simpson does not increase the monetary bond. He doesn't remand him. He doesn't escalate custody. Instead, he does something far more precise. He removes access. Phone privileges gone. Contact prohibited. Communication severed. Why? Because the court identified the source of risk: interaction. This ruling is surgical. It preserves the defendant's release while neutralizing the behavior that alarmed the court. It reflects a core principle of bond law: restrict only what is necessary to protect the process and the people involved. And notice the judge's final words. If he thinks I'm going to put up with his behavior, I'm not doing it. That isn't anger. That's authority. This entire hearing becomes a lesson in how courts measure trust. It's not about who you claim to be. It's about how you act under pressure. Missed dates, interruptions, blame, patterns. Every piece accumulates. By the end, the court isn't judging character. It's managing risk. And that's what bond truly is: a balance between freedom and protection. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.